If you own a business in Ohio and you die without a succession plan, the business you spent years building may not survive you. That sentence is not a scare tactic. It is what Ohio law does by default. A sole proprietorship generally dissolves at the owner's death. A multi-owner business without a buy-sell agreement can leave surviving partners stranded. The deceased owner's family may become new co-owners with no mechanism in place to buy them out. A family business with no clear successor may have to sell at whatever price a distressed market offers, which is rarely the price the owner had in mind. The most expensive paragraph in a business owner's life is often the one that was never drafted. This video is about drafting it before it is needed. I'm Andrew C. Goodwin, the principal attorney at Rhodium Law. I practice estate planning and business law, and a meaningful part of what we do is help Ohio business owners build the legal framework that protects what they have spent years constructing. My background matters here. Before I went to law school, I spent more than 15 years in technology. After law school, I worked at a large law firm and then served as in-house counsel at a global health system where I drafted, reviewed, and negotiated complex commercial agreements for years. I understand agreements and how they work. I know what buy-sell provisions do and what they fail to do when they are missing. I also know this from the personal side. The early days of the pandemic, I recognized that my mother needed care, dementia, and kidney disease. She needed someone close by 24/7. I stepped away from my career path and spent 5.5 years as her primary caregiver. That season shaped why I practice the way I practice. The plan you draft is the difference between a family that stays whole and one that fractures under pressure. Let me walk through what actually happens to an Ohio business when the owner dies without a plan. There are 4 scenarios, and in my experience, many business owners are not aware of any of them until it is too late. Outcome 1, the sole proprietor. A sole proprietorship is legally inseparable from its owner. When the owner dies, the business generally dissolves. Ongoing contracts may terminate. Client relationships typically do not transfer. Whatever goodwill the owner built over 20 years can evaporate within weeks. The family is left with equipment, perhaps some receivables, and no ongoing enterprise to sell. Outcome 2, the multi-owner business without a buy-sell agreement. If one owner dies and there is no buy-sell agreement in place, the surviving owners may find themselves in business with the deceased owner's spouse or children. That is not a legal technicality. It is a practical Monday morning reality. New partners who did not choose this, no operating agreement provisions covering the situation, and no mechanism to buy them out. Outcome 3, the family business with no clear successor. When a closely held family business has no documented transition plan, the family may be forced to sell quickly, under pressure, and at distressed prices. Strategic buyers and financial buyers both know when a seller is in a difficult position. The market reflects that knowledge. The estate tax valuation issue. When a business owner dies, the IRS may value the business interest for estate tax purposes under methods that produce a higher number than the owner expected. Without a succession plan that documents valuation methodology and ownership transition, that valuation can be disputed in ways that cost the estate meaningful time and money. A succession plan is built around one question. What is supposed to happen to this business when you can no longer run it? The answer generally falls into one of 3 structures. Structure 1, sale to a third party. A strategic buyer is typically a competitor or industry player acquiring the business for its customer base, contracts, and/or market position. A financial buyer, such as a private equity group, is acquiring it for cash flow and eventual resale. Third-party sales can produce strong prices, but they require time, preparation, and planning that generally begins years before the sale, not after the owner dies. A business sold under duress, without documented processes, without audited financials, and without a clear transition roadmap, typically sells for less than it would under orderly conditions. Structure 2, intra-family transfer. Transferring a business within the family can be done as a gift, a sale, or a hybrid. A gift carries gift tax implications. A sale to a family member typically involves installment notes and may require a formal valuation. A hybrid structure, such as a sale at a discount combined with a contemporaneous gift of the remaining interest, can be used to move value while managing tax exposure. Each approach carries Ohio-specific considerations, and none of them should be structured without proper legal and tax counsel. Structure 3, sale to employees or management. If the right buyer is already inside the business, a management buyout or an employee stock ownership plan may be worth considering. A management buyout typically involves a sale to key employees, often financed through a combination of installment notes and third-party debt. An employee stock ownership plan, commonly called an ESOP, is a more complex structure designed to transfer ownership to employees collectively with meaningful tax advantages for qualifying businesses. ESOPs are generally not appropriate for smaller businesses, and the threshold requirements are significant. But for mid-market Ohio companies with the right profile, they can be a compelling option worth exploring with the right advisors. The structure you choose determines what follows: the buy-sell agreement, the insurance strategy, the estate plan coordination. Choosing the right one while you are alive and operating is the most consequential decision in this entire process. For most Ohio multi-owner businesses, the operational centerpiece of any succession plan is the buy-sell agreement. Let me walk through what it does, how it works, and where the common gaps show up. What a buy-sell agreement does. A buy-sell agreement is a legally binding contract between business co-owners that establishes what happens to an ownership interest when a triggering event occurs. The most common triggering events are death, disability, retirement, divorce, and bankruptcy. Without this agreement, none of those events have a defined resolution. The surviving owners and the departing owner's estate and the business itself are all left without clear direction. Cross-purchase versus entity purchase. There are two primary buy-sell structures. In a cross-purchase agreement, the remaining owners personally agree to purchase the departing owner's interest. In an entity purchase agreement, also called a stock redemption agreement, the business entity itself agrees to buy back the interest. Each structure has different tax implications, particularly around basis step-up, and the right choice generally depends on the number of owners, the entity type, and the tax situation of the owners involved. Valuation methodology. One of the most contested areas in buy-sell agreements is how the business is valued at the time of a triggering event. Common approaches include a fixed price set at signing, a formula tied to revenue or earnings, an agreed value process where owners confirm the value periodically, and a third-party appraisal performed by a qualified business appraiser. Each has trade-offs. A fixed price that was set 5 years ago may bear no relationship to today's business value. A formula that made sense at formation may not capture the current reality of the business. Buy-sell agreements with stale valuations can produce disputes rather than smooth transitions. Funding mechanisms. Here's where I often see a gap that business owners do not know about. A buy-sell agreement describes what should happen. A funding mechanism is what makes it possible. The most common funding method is life insurance. Each owner or the business holds a policy on the others so that the purchase price is available at death. The right policy structure, ownership arrangement, and benefit amount depend on your specific buy-sell terms. I encourage owners to work with a qualified insurance agent who understands buy-sell funding so the policy actually does what the agreement requires. Other mechanisms include installment notes, where the buyer pays over time out of business cash flow, and sinking fund arrangements, where cash is accumulated in a dedicated reserve. Without a funding mechanism, the buy-sell agreement is a contract built on a promise with no resources behind it. There is a separate insurance question that goes beyond the buy-sell. It's called key person life insurance, and it is frequently overlooked. Here's the distinction. The life insurance used to fund a buy-sell agreement is designed to finance the ownership transfer. Key person insurance is designed to keep the business operational after the loss of a person whose skills, client relationships, or leadership are critical to the business. The policy is owned by the business. The business pays the premiums. The business is the beneficiary. When the key person dies, the proceeds go to the business, not the family. Those proceeds are available to cover operational disruption, manage the transition period with existing clients, recruit and train a replacement, and service debt obligations that might otherwise go into default. For a business where one person drives a meaningful portion of revenue, or where client relationships are concentrated in that person, a key person policy is generally part of a responsible planning structure. The specific coverage amount and policy design depend on the business's financial profile and the risk concentration that person represents. A qualified insurance agent who understands business owner planning can help size the coverage appropriately for your situation. A business succession plan that is not coordinated with the owner's personal estate plan can create a gap that surfaces at the worst possible moment. Here's a version of that gap I see in practice. An Ohio LLC owner creates a thorough personal estate plan with a revocable living trust. The trust is properly drafted and funded with personal assets, but the operating agreement of the LLC has transfer restriction provisions that were never reviewed in the context of the trust. The owner dies. The LLC interest now has to pass through the trust, but the operating agreement's restrictions require the consent of other members before any transfer, including a transfer at death, which no one anticipated. The fix for this is not complicated, but it requires intentional coordination. The operating agreement should define which transfers are permitted without member consent, and that list should include transfers to a revocable living trust for estate planning purposes. The trust should be a permitted transferee under the operating agreement, and the overall estate plan should reflect the ownership interest with clear distribution instructions. A second coordination point is the LLC interest itself. If an LLC interest is not properly addressed in the estate plan, it may end up in probate even when the owner's other assets pass through the trust. An LLC interest is a personal property interest. Without specific provisions addressing it, it follows the default rules, which may include probate. Let me close the technical portion of this video with 5 mistakes I see in Ohio business succession planning. Mistake 1, no buy-sell agreement. This is a common situation in smaller multi-owner Ohio businesses. The owners know each other, trust each other, and assume they will figure it out when the time comes. The time comes. No one is prepared. Mistake 2, a buy-sell agreement that exists but has not been updated. The agreement was signed at formation. It has a fixed price from 7 years ago. The business has grown. The price is no longer realistic. When a triggering event happens, the parties may dispute whether the fixed price controls or whether current value should apply. The answer depends on how the agreement was drafted, and the dispute can be costly. Periodic valuation review with a qualified business appraiser keeps the agreement aligned with the actual value of the business. Mistake 3, a buy-sell agreement with no funding mechanism. The agreement obligates the surviving partners to purchase the deceased owner's interest. There is no life insurance. There is no reserve. The surviving partners cannot afford to execute the purchase. The estate cannot wait. The business has no clear path forward. Mistake 4, the sole proprietor who assumes the family will sell it. As I described earlier, a sole proprietorship generally dissolves at the owner's death. The business is the owner. Without the owner, there may be no transferable enterprise. Planning for this requires a different structure, and it requires that structure to be in place before the event. Mistake 5, an estate plan and an operating agreement that are inconsistent. The estate plan says the LLC interest goes to the trust. The operating agreement says a member's interest cannot be transferred without unanimous member consent. These two documents were never coordinated. The family learns about the conflict in the middle of an estate administration. There's a question I've seen Ohio business owners quietly wrestle with when this topic comes up. It's not really a legal question. It's something closer to, does it matter what happens after I'm gone? I think it does. Not because of the money, although the money matters too. It matters because the people who worked alongside you, the partners who bet on the same idea you did, the family who watched you carry that business through hard years, deserve to know that the work continues, or that it ends on your terms, not on the terms the state assigns by default. A business succession plan is not preparation for failure. It is the final expression of the same intentional thinking that built the business in the first place. You made deliberate decisions at every stage of building. The succession plan is one more deliberate decision. It is the one that says, I thought about this. I made the call. The people I care about will not have to guess. That is worth doing, and it is worth doing correctly while you still can. The plan you draft for the business is the same kind of intentional decision that built it. It is what your partners, your family, and the work itself carry forward when you are no longer at the helm. If this was useful, subscribe. We publish a new video each week to educate Ohio families and business owners on estate planning and succession so they can make an informed decision before it's too late. One last thing, I am an attorney, but watching this video does not make me your attorney. This video is general information and does not constitute legal advice. Business succession planning depends on your entity structure, family situation, and tax posture. The right structures for your business depend on your specific facts, and that conversation belongs with a qualified Ohio attorney who can look at them with you. Strategize, secure, shine. I'll see you soon.